Hello neighbor, I'm Robert Burns, and we are standing directly in front of the State Board of Cosmetology. Today is October the 3rd of 2016, and the board has graciously permitted me the opportunity to make a presentation with regard to the two-instructor rule. And we're going to show you that presentation. Let me just say this, I have standing beside me Miss Nelda Dural. She has been featured on several of our videos. We're so pleased you were able to come and join us today, Miss Dural. And basically, we're going to give you a link for a chronological sequence of events that has transpired with regard to the requirement that this board has for having two instructors. Basically, I'm going to just give it a quick nutshell. The board enacted this as a statute in 2010. It slept for about 3 or 4 years, not being enforced. Then suddenly somebody fell out of bed, and despite Ms. Dural having had 3 or 4 inspections prior to 2015 in which she was not cited for having only one instructor, that being herself. By the way, the old rule required that you had to have 20 or more students. But here's a key point. The board failed miserably to promulgate that statute into first they didn't publish it in the Louisiana Registry, and then secondly they did not promulgate this into Title 46, commonly known as the goal book for this profession. And to make an analogy, just as I said in the meeting, that would be analogous to the legislature enacting a reduced speed zone, which they have over the Atchafalaya Basin from 65 to 60. State police saying, hey, Department of Transportation and Development, you don't need to fool with going out there and putting updated speed limit signs. The statute's passed. Well, as you would well know, if a state trooper pulls you over and said, hey, you were going 65 miles an hour, I'm citing you for speeding, your defense is going to be, hey, the sign said I could go 65 miles an hour, and it would be unenforceable in a court of law. Now, let me just say this. The board is, Miss Morris, one of the 2 attorneys for the board, you'll see that she does not want me speaking on this topic because there's been litigation involving Miss Dural. But we're gonna break away for just a moment because I want you to see just how vigorously Miss Morris grilled her over this 2-instructor requirement. Let's break away for just a moment.
Okay, Louisiana Revised Statute, Title 37, Section 595, Paragraph A, Subparagraph 4 says employ at least 2 instructors. This is listed under requirements of schools, but you don't understand what it means to employ at least 2 instructors.
I didn't understand it because I felt like the beginning of the book said 1 instructor. The second half of the book said 2 instructors. So there was a conflict going on. Why was there 2 different divisions? One side said 1 instructor, the other part of the book said 2 instructors.
Did you, Mr. Rao, actually just chose to ignore that provision? Isn't that correct?
No, ma'am.
If you don't dispute the fact that since 2010, you have operated a school with 1 instructor.
I have never been written up or told or send a paper saying that I needed to have 2 instructors. I have never gotten any type of memo from Louisiana State Board of Cosmetology since I opened saying that I needed a 2nd instructor until Ms. Sherry Stockstill showed up. If I had known I was not in compliance, I would have tried to accommodate it. This came as a whirlwind to me all of a sudden, saying that I needed an instructor. It took me by surprise, and I couldn't understand why I needed 2 instructors.
Okay. But in order for your students to pass the state cosmetology test, you don't review these requirements with them?
Yes, I do, but I do know there's a new school in New Orleans, which just got approved last month. And they were approved by the board to have 1 instructor. Why do I have to have 2 instructors when the school in New Orleans has 1 instructor? They were just approved the last time I came to the board, January, February, March, at the hearing before I came. What's the difference? Why she was allowed to have 1 instructor when Nelda has to have 2 instructors? What's really going on in here? I just don't understand. It seems like I just can't get no cooperation.
All right, we're back with you. You saw how much she grilled on that particular issue, so it's understandable as to why there would want to be, hey, let's not discuss at this time, saying it would be part of a litigation. Now, they did put 1 case on the agenda. It's a mystery why they didn't put Mr. Rao's case on the agenda, therefore trying to say it's off limits and I can't discuss it, but you can see why they may not want to discuss this particular issue. Now, I want to point out to you, if you look at that document that we gave you, we visited with a young lady named Miss Brindley at the Louisiana Registry, and she is the one that provided this authoritative information that the board failed to put it into the Louisiana Registry. They failed to promulgate it into Title 46. Promulgate basically means to make widely known, and so therefore the statute would be unenforceable, notwithstanding that normally a statute does trump a rule. In fact, I offered her anonymity for me to make this presentation today, and she said, no, don't you worry, put my name out there, put my number. The board dropped, or more specifically, the board's attorneys dropped the ball on this, and I'm quoting her, quote, they should have known better, and in all likelihood do know better, unquote. She described what happened with Mr. Dural as a, quote, tragedy, that's correct, and also that if this was a larger board or commission, they never would have tried anything like this because they know they can't get away with it. But as you may note, and the Cosmetology Board is not unique to that. A lot of these little small boards, they get away with whatever they can. We do as we say, and see if nobody catches us, no harm, no foul. So I'm going to ask Mr. Dural, you've been through the appeals process, and I want to point out one last thing. All of the ones who made the decision with regard to Mr. Dural, every one of them was a Bobby Jindal appointee. All right. Now, when we had this meeting today, there's still 2 Bobby Jindal holdovers from the old board, specifically longtime Chairman Francis Hand and also Jill Hebert. Interestingly enough, neither was present at the board meeting today. So every board member who was present on this video is a John Bel Edwards appointee. And it's no secret I am not a John Bel Edwards appointee. I'm sorry, a John Bel Edwards fan. But nevertheless, I'm putting him on the spot here about whether you're going to do the right thing. Public schools, Raynetta Frazier, public cosmetology schools are being closed down. And I would contend that that is inhibiting economic opportunities for many who otherwise would be able to pursue them. Mr. Dural, I think you can testify, and I think you did so previously in your hearing, that you do help an awful lot of shall we say, challenged individuals, that this gives them an opportunity to be able to pursue a very viable career. Is that correct?
Mr. Burns, that's exactly correct. The ratio has always been 20-to-1. We serve a small population of kids that are very much deprived. Some have learning disabilities and don't come from the best environment. So my school was really a school that allowed these students to get a license and go on to work. And because of the challenge with the two teachers, it has caused Ms. Sherry Morris herself sent a letter to my attorney Ed Landry saying, tell Nelda just do not enroll any students. That happened in the latter part of March. Since March, I have not been able to enroll any students or open my school to the public. The students were just sent out of the school without any opportunity for me to do a teach out plan to have these remainder of the students get their licenses. It was just a one-day shutdown thing. Tell Nelda, do not enroll any students. The Judge Johnson had said initially for Mr. Edward Landry and Miss Morris to settle this between themselves and don't bring this back to his courtroom, to his house. And so we were under the impression that it would be settled like that. But Ms. Morris refused to settle this, and I've seen on other occasions where other school owners have had situations in state board where they have specifically told these school owners, you all go and settle it. But they refused to settle it. As a result, my students were sent out without their license, and my school has been shut down. I've been forced to file bankruptcy. And the problem with this is the law is unenforceable. The two-teacher situation is totally unenforceable because it was not promulgated, it was not published to the public, to the schools, nor the schools nor the inspectors knew that the two-teacher rule was being enforced. And besides, they let this rule sleep for 4 years. They sent it before legislature, they let it sleep for 4 years. After the 4 years, then they decided, oh, we're gonna choose and pick when we use this two-teacher situation, and we're gonna use it on Ms. Dural. I had students call me to tell me before this even happened, you need to go to the state board meeting because they're going to call the students in first to bash you, muddy the water, and nasty your name up. Donna Bork called me to let me know this. I showed up to the very first meeting and they had the students talking to the board members. It's not this current board, it was the Bobby Jindal board. And like Robert said, all but 2 of those board members are gone. They called the students in 1 month and called me in the next month. The way they got me into the board is with the administrative hearing with the 2 teacher situation, which was totally unenforceable.
Now, and she makes an excellent point about the unenforceability, but it gets better than that. On April the 13th of 2015, some 6 weeks prior to bringing her in for this hearing, they granted an exception.
Yes,
did they not?
did. Yes,
now, this
they
is
did.
a statute, okay? This is a statute. And we're going to give you a direct link for the exception being made. I don't want you to take my word for it. You will see in the April 13th, 2015 minutes where they granted an exception to this statute. So they're going to pick and choose whom they will have to say you've got to adhere to the statute and you do not. And as she says, that was the premise behind which she was brought in for a hearing. And I want to point out just a couple of other things, and then we're going to go back in because we're continuing to monitor this present board meeting. But I want to bring up just a couple of other things. One of the students that was placed on the stand, I believe her name was Miss Ortega, is that correct?
Yes, it is.
And she stated under oath that Steve Young, the executive director, instructed those students not to go to her school because it was a, quote, threatening environment. I want to break away for just a moment and let's take a look at Miss Ortega's testimony under oath about Steve Young having said this about Mr. Dural's school. Let's break away for just a moment.
Mr. Steve told her not to come back to the school, but
You keep saying Mr. Steve. Who are you talking?
Mr. Steve Young, he's the executive director here.
You understand he told her not to come back to the school?
That's what I'm told.
Now, you said Steve Young asked you not to go back to school.
He said it would be unhealthy for me to go back
And why was it unhealthy for you to go back?
because there was a threatening atmosphere at the school.
Threatening in that she was difficult with the students?
Threatening in that threats were made towards students.
Threats were made to the students. And so you called him and he told you not to go back to the hours you had?
All right, you just saw the testimony. Now, I want to bring up just a couple of other points, and that is, I remember one young lady,
Wait, Robert, I want to mention this before he goes to the next point. Not only did he tell Dina Ortega, she said on the witness stand, not to come to my school, but Dina and another student, Angela Bodan, was sent to the New Iberia Sheriff Department to file a complaint saying that I was still in their hours. There was a state board investigation and I was still in the hours. What's interesting to me is before the hearing ever came up, there was a police report saying that I was still in hours. So I was being accused of all of this before it even got to the state board for the administrative hearing.
well, an excellent point there, and I want to make just a couple of other quick points. I don't recall a single student getting on the stand and saying that Mr. Rao was a poor instructor. Quite to the contrary, I remember an oil field service worker who said she was an excellent instructor. He just objected to being charged for not having attended the classes during the time frame that he should have, and so there was a thing that's called an overage in the industry, and he signed a contract requiring him to pay that. There was another lady, I believe she was one of the first witnesses, and she said that, and I'm quoting her, my husband would kill me.
Donna Bork.
Okay, thank you, Donna Bork. My husband would kill me if he found out that I had enrolled in this school, and I don't know whether it was $7,500, $8,000, whatever it was. The point is, my husband was going to be mad as hell about it. Well, that's supposed to be Mr. Rao's fault? Now, she readily admitted that I lost interest in the school and I quit attending.
That I lied. I went to the casino instead of going to school and just all types of things.
But now she wants her money back. Well, as Edward Landry, her defense attorney for this hearing, pointed out, all of that, to the extent they may have had any validity to their complaint, it should have been litigated in a civil courtroom. No board is supposed to get involved in contractual disputes, and that's what happened here. So you have the two instructor rule, which an expert, Ms. Brindley, has said is unenforceable, and then you have The remainder of the complaints being that students weren't happy. I've signed contracts I wasn't happy with, but I got to live with it, okay? That's life. What ended up happening here, she's volunteered that she filed bankruptcy. The board attempted to hit her with almost $50,000 in administrative costs. They spent 3 days on all this stuff. Almost $50,000, okay? That alone is going to put anybody out of business.
Yes.
But here's the problem. It's bankrupted her. It has literally taken her livelihood.
Exactly.
And every bit of it appears to be, I'm going to be very kind and say extremely suspect. Okay, but I'm being very kind in characterizing it that way. So the ball is now in Governor Edwards' court, his new appointees court. I do not know if they're going to attempt to overturn Governor Jindal's board's ruling or not. I do know that I'm going to hold them and Governor Edwards accountable. Governor Edwards has run on the platform of saying that he supports minorities, the underprivileged. And look, I don't mind bragging on a governor when he does a great thing. I did so when Governor Edwards appointed Freddie Phillips to the Auctioneers License Board. Going to give you a link to a very positive post that I put out. Unfortunately, the powers that be within the auction industry got to him, and he rescinded that appointment 16 days later. Obviously, that's not setting very well with me, but he is governor. He can do what he wants. Likewise, he and this board can do what they want about the previous decision made under the Jindal board. But I am going to let you know this, Governor Edwards. If you decide to uphold this, it becomes on your watch. And I don't believe this is indicative of providing economic opportunities for minorities and others. And I do think it's a travesty. It's not just with Ms. Dural. Ms. Frazier shouldn't have to live in fear that her public school is going to be shut down at any time. Yet they've sent a letter saying, hey, if you don't get a second, told her school board, if you don't get a second instructor, we're going to shut you down. That is not conducive. John White, very briefly, has made the statement that cosmetology is not a high-wage, high-growth industry, so he's not going to get involved with his 2-instructor requirement and the fact that the schools are being closed down. But, I hate to break, I think John White's a good guy, but not everybody can be an engineer. Not everybody can go out there and be a physicist. And this is providing an opportunity for entrepreneurship to make a living, and it is being provided to some that are somewhat limited in their abilities to gain skills to make a trade. And I believe it is a travesty to have the lower cost schools such as Mr. Rouse closed down, as well as the public schools, which basically don't charge tuition, all in the name of continuing to glorify these high-priced, expensive private schools, which I'm going. What all has transpired with regard to the 2-instructor requirement. For background purposes, the board went before the legislature in the 2010 session, succeeded in passing a bill, House Bill 1028 by Wayne Waddell, that became Act 728 of the 2020 legislature, that was subsequently codified into revised statute 37595A4 and became effective on 8/15/10, and I quoted it verbatim: each school shall employ at least 2 instructors, persons who are teachers registered by the board, at least one of whom shall have been a registered teacher and in active practice for at least 18 months. Now, when this was passed, the board never did publish the requirements into the Louisiana Registry, nor was it ever promulgated into Title 46, which is commonly known by the practitioners in the industry as the Gold Book, for dissemination out to licensed school instructors. And I have the applicable page back toward the rear, I think it's about the 4th page of the Gold Book section with a highlighted portion. And as you can see, the wording remains unchanged in saying that faculty, all schools must maintain a faculty of at least 1 instructor per every 20 students enrolled. Each faculty shall include a senior instructor who shall have at least 18 months teaching experience in an accredited school of cosmetology. The senior instructor shall supervise all other faculty members. Now, as I think most everyone is aware, Nelda Dural, and that's who I am waiting on. Her school was inspected basically annually, from the time this statute was.
Interrupt you for 1 second and remind the board that there is pending litigation between the board and Mr. Dural.
Yes.
So we're not going to discuss any pending litigation matters.
Well,
It's not on the agenda.
well, okay, then a generic person was shut down, and proceeding on the timeline to April 13th of 2015, and that's I think the second to last page on the material that I provided to you. And I think I read that out. In fact, I know I did at a previous meeting with this current board. There was an exception granted on April 13, 2015 to the statute. You can see the minutes on April 13th of 2015. Despite both attorneys being aware that it was a statute, this board, and both were present that day, the board approved that exception, and the exception was placed. Now, I'm just stating simple fact here. I mean, it's simple fact. In talking about the history, on June 5th, 2015, the board did hold a hearing in which Ms. Dural was cited for failing to conform to the 2-instructor rule. That's not pending litigation, that's simple fact.
That's part of the pending litigation. That's one of the violations of the pending litigation.
Okay, and well, for future reference, you can read the material. I think it's quite laid out, and I think Ms. Morris, I've got her quoted in here. I've got the video if anyone wants to see it. So, proceeding on, is a statement of fact that on August 14, 2015, a conclusions of fact, findings of fact and conclusions of law were entered in there too. I won't discuss the specifics since you pretty much declared that off limits. And on September 9, 2015, there was an appeal filed. Interestingly enough, on June the 13th of this year, which I believe this current board was in session for, Renetta Frazier appeared before the LSBC, fearing that her own cosmetology class, which she provides to public school students, may come to an end as well as a result of her school board indicating they just simply can't justify paying for a second instructor to fulfill the statutory requirement. Frazier emphasized that she had, quote, never been deemed in violation in all the years that she had been conducting classes with only one instructor. Now, the next section, which is September 8, 2016, that goes to the crux of what I've got here. I would encourage every board member to read this, and I can see why Ms. Morris would not want it discussed. But normally when I consult folk on a matter like this, I volunteer that they can maintain their anonymity. Ms. Brindley told me very emphatically that there was no need to maintain her anonymity, and that's why you see her name, that's why you see her phone number, and she described what happened as a tragedy, the failure to disseminate those into the Louisiana Registry and to promulgate it into Title 46, aka the Gold Book. The analogy basically is that if the legislature passed a statute, which they did, to lower the speed limit from 65 miles an hour to 60 miles an hour over the Atchafalaya Basin, and state police said, hey look, Department of Transportation and Development, don't worry about going out and putting new signs. I mean, it's just understood, we've passed a statute. It's not going to be enforceable, all right? If the speed limit signs still say 65 miles an hour and a trooper pulls you over saying, hey look, Mr. Williams, you violated the, I did get it right, didn't I?
Yes, you did.
Or Pastor Williams, I mean. You've violated this speed limit here. Your quick defense, and it's not going to be enforceable in court, is that the sign says 65. That's the analogy of the failure to promulgate this into the Louisiana Registry. And so I'm going to talk in generic terms specifically for someone like Ms. Frazier. It's not enforceable. And I mean, Ms. Brindley could not have been more emphatic. And she said, don't hesitate to use my name. And she said, both the attorneys of this board know better. And she also said that were this a larger board, there is no way this could have been pulled off because they would have known you couldn't pull it off. Now, here's her phone number. Anybody's welcome to call her on that matter. I wouldn't be putting, like I said, normally I offer anonymity. she was very emphatic. She didn't want anonymity. She's well aware of what happened in this case. She also provided another case involving a very similar nature. The electrolysis board and Pauline Poole, all of this information came from her. And she said it was very similar in nature, and that Ms. Poole was offered the opportunity to take either of two remedies. Now, my own belief is that the prior board that sat here, two of which the prior members I noticed aren't here today, that there was a blunder here. And I think it would be in this current board's best interest to correct the situation. Obviously that's up to you, but I don't think that it is conducive for the present administration to be perceived as closing down public schools that provide an opportunity for those who are disadvantaged. I'm not a fan of the governor, that's no big secret. I don't make a secret of that, but I'm willing to compliment someone when they do the right thing. And that would be the case if this trend does tend to dissipate. Now, John White did appear before the press club last Monday. I did ask him about this situation of public schools being closed down as a result of the failure to conform to the 2 instructor requirement. I will have to say that Ms. Hand appeared to basically, what she said appeared to be pretty accurate in terms of Mr. White's philosophy on cosmetology in general. He did say, and I have him captured on video, that the Department of Education does not view cosmetology as being a high growth, high wage, I'm just quoting him, focus. And so he said that the Department of Education was merely going to be concerned about teaching entrepreneurship, and cosmetology would be considered a component within that.
Excuse me, Mr. Burns.
That's it.
We give you, okay.
That's basically
Thank you so
it.
much.
You're quite welcome.
Appreciate your comments.
What's that?
Appreciate your comments.
You're quite welcome. And I appreciate your indulgence. If anybody got a question, I'll be happy to answer it. But I think the material that I've left with you should further elaborate.
Thank you.
You're welcome. I'm going to close by saying that dominated the composition of the Bobby Jindal board. I want to thank you for having tuned into this video segment. I'm going to give Ms. Nelda, Mr. Dural, just a brief moment to say a closing comment, and with that, we're going to wrap this up and get back inside and see how the rest of this meeting transpires.
The one thing I want to say in this section is we have very few African American schools. So if we have 50 schools in the state of Louisiana, we may only have 5 Black-owned cosmetology schools. And what is the sad thing is, the Bobby Jindal board went before the legislature. Previously, you, in order to open up a school, you had to purchase a $5,000 bond. The Bobby Jindal board went before the legislature and say it becomes a $30,000 bond, which prevents the smaller businesses or future school owners from opening up a school. This has been the tragedy for years and years and years and years, some 30 years back. This is nothing new to the cosmetology industry. This is something that's been going on. We want a change. Change has come, and we want a change. We're willing to work for a change, but we want an equal opportunity just like everybody else.
Thank you so much, Mr. Rao. Thank you for all the
Burns.
dedication of you coming before this board and for agreeing to this video. We don't know what the outcome is going to be. It rests with this board. You're going to get the link to the material that we provided to them. We will stay on top of it, and if it's reversed, I'm going to compliment Governor Edwards on his new appointees. I don't mind doing that, even though I'm not a John Bel Edwards. I'm fair, even though I'm not a supporter of his. But I'm also going to tell you, if he allows what happened under the Jindal administration to stand, I'm going to smear him with it. Because for me, it's fair game. And you inherit some things, it's up to you if you want to continue to propagate them. Once again, this is Robert Burns. We are so thankful that you've tuned in for this segment. And we look forward to bringing you the next Sound Off Louisiana feature. Thank you so much.
Thank you.